Right, let's settle down, everyone. Good morning. Today, we're jumping straight into a very crucial explainer on the Transfer of Property Act. We are focusing strictly on how you're going to structure a flawless, maximum marks answer for your KSLU exam on the topic of gifts. Question 26 is a recurring heavyweight, and honestly, how you present your knowledge is just as critical as the knowledge itself. We're going to approach this exactly as a senior evaluator expects to see it on your answer script. So, to score that perfect 16 marks, your answer script absolutely must follow this strict structural hierarchy. We'll be looking at the statutory definition, the essentials of a valid gift, the kinds of gifts, rules for revocation, and the landmark case laws. This covers sections 122 to 129. Let's get into it. Section 1, the statutory definition of a gift. Now listen carefully. You must always open your exam answer with the exact statutory definition. Please, never paraphrase the law in your opening paragraph. Section 122 states, the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person, donor, to another, Donee, and accepted by or on behalf of the Donee. I want you to write this bare act provision verbatim. Then take your pen and deliberately underline the words existing property, voluntarily, and without consideration. The evaluator has to see that you know the bedrock elements of this transaction right from the very first sentence. Here's a pro tip for your answer script. Literally draw a line right down the middle of your page to clearly define the parties. On the left side, put donor, the person making the gift. On the right, Donee, the person receiving it. This clean bifurcation immediately signals clarity of thought, and trust me, it prevents a lot of confusion when you start drafting your complex case law examples later on. Moving to Section 2. The essentials of a valid gift. There are 6 statutory conditions you need to memorize. First off, the transfer of existing property. You need to explicitly state that any gift of future property is void ab initio. You simply cannot gift what you don't actually own yet. Second, voluntary transfer. The consent here must be absolutely free from coercion, fraud, or undue influence, exactly as it's defined under the Indian Contract Act. Third, and this is huge, it must be without consideration. It has to be entirely gratuitous. Even a single rupee given in return completely vitiates the transaction, right? It turns a gift into a sale. Why? Because consideration introduces a contractual exchange, which destroys the purely gratuitous essence of a gift under the Act. Fourth, competent parties. Now, while a donee can be literally anyone, even a minor, the donor must be legally competent to contract. That means they must be of the age of majority and of sound mind. Fifth is acceptance under Section 122. I heavily emphasize this in my classes. Acceptance is mandatory, and it must happen while the donor is still alive and mentally capable. If the donor passes away before acceptance, the gift fails entirely. The law doesn't just presume acceptance, it has to be demonstrably given. And finally, the 6th point, the mode of transfer under Section 123. For Section 123, present this exact bifurcation on your paper. For immovable property, it must be by a registered instrument, signed by the donor, and it strictly requires attestation by at least 2 witnesses. The registration part is absolute and non-negotiable to prevent fraud. Now, for movable property, it can be by delivery or a registered document. Physical delivery is perfectly sufficient for movables, but hey, if the parties prefer, a registered document is equally valid. Let's move on to Section 3, the kinds of gifts. You're going to systematically write down these 4 distinct classifications. First, a simple gift, which is just your standard, absolute, unconditional transfer. Second, the onerous gift. Now, you must write down Section 127 here to secure those extra marks. This is a gift burdened with an obligation. The rule is very straightforward. He who accepts the benefit must accept the burden. The donee has to accept it fully or reject it entirely. Third is the universal gift under Section 128, where the donor gifts their entire property. But wait, that makes the donee personally liable for the donor's debts up to the property's value. And fourth, the conditional gift, which is subject strictly to lawful and moral conditions. Section 4, the rules for revocation under Section 126. Let me issue a very strict warning right here, class. The rules of revocation are a massive trap in KSLU grading. So many students mistakenly write that a donor can simply take back a gift whenever they feel like it. They absolutely cannot. Section 126 permits valid revocation in only 2 specific scenarios. First, by mutual agreement, where both parties agree beforehand that the gift shall be suspended or revoked upon a specified event. But note, this condition must be lawful and absolutely cannot depend merely on the donor's personal whim. Second, on contract grounds. If the original consent was vitiated by fraud, coercion, undue influence, or misrepresentation, the gift can be revoked in a court of law. So to recap, a gift cannot be revoked once validly completed. It cannot be revoked on a mere change of mind, and it cannot be revoked if the condition is illegal or immoral. Listen, completed gifts cannot be revoked just because someone had second thoughts. If you grant a gift today and deeply regret it tomorrow, well, the law offers absolutely no remedy. Furthermore, if the condition for revocation is illegal or immoral, the condition itself is void, and the gift remains absolute. Underline this principle heavily in your exam booklet. It really demonstrates your absolute grasp of statutory intent. Let's look at some examples, because KSLU evaluators actively look for clear examples. I want you to write these precise illustrations exactly like this. Here's a valid scenario. A gifts a house to B with a condition that it will be revoked if B dies before A. This is totally valid. It's a specified event that doesn't depend on the donor's will. Now, the not allowed scenario. A gifts property and later merely wants it back. That is legally barred. Using these direct A and B illustrations is the absolute hallmark of top-scoring law students. Okay, Section 5, Landmark Case Laws. This is what separates an average script from a brilliant one. Our first landmark case is Renikuntala Rajama versus K. Sarwanama. The quote to remember is, "Validity of gift depends on acceptance and intention. On your KSLU answer booklet, draw a distinct, prominent box around this case name." The background facts here are fascinating. A donor executed a registered gift deed, but she retained a life interest, so she could enjoy the property's benefits during her lifetime. Naturally, a dispute arose over whether retaining possession actually invalidated the gift. The final ratio decidendi by the Supreme Court was that physical possession is not the sine qua non, the essential condition for a valid gift. Now, what's the absolute relevance of this case? It's that retaining a life interest does not destroy the validity of the transfer, provided the intention and the acceptance are unequivocally established. Next up is the extremely crucial judgment of Gamtibai versus Matulal. Gift once completed cannot be revoked except as per Section 126. Heavily underline this case to immediately capture the evaluator's attention. Here are the facts. A donor executed a gift deed, but due to a sudden change of heart, they actually attempted to cancel it before the formal registration concluded. The court's final verdict? Uncompromising. The ratio decidendis cements the absolute strictness of Section 126. A completed gift is final. The sheer relevance of this case is that it definitively shuts the door on any donor trying to use a change of mind as a legal defense. Registration is deemed a mere procedural step. The legal binding happens the exact moment execution and acceptance align. Which brings us to the conclusion. A voluntary, gratuitous transfer requiring strict statutory compliance. Once validly made, it is generally irrevocable. To finish your exam answer, please do not let your essay simply trail off into nothing. Provide a tightly structured conclusion paragraph. Write exactly this. A validly made gift is generally irrevocable. It is a voluntary, gratuitous transfer requiring strict statutory compliance. By structuring your paper this way, you literally leave no room for the evaluator to deduct marks. So class, having thoroughly dissected the rigid anatomy of Section 122, can you now perfectly structure this high-scoring answer on your next exam? And more importantly, does the law's absolute refusal to accommodate human regret make a gift the most dangerous transfer of property there is? Think about that. Read your Bear Act thoroughly tonight. Settle your doubts and prepare for success.